kindly put your phones on airplane mode or silent. Please. There is that I at any moment, so please put your phones on silent mode or keep it on airplane.
Greetings to everyone. Welcome you all to the first Atal Bihari Vajpayee National Football Competition 2054. This is Saida Rao. Greetings to everyone. Welcome you all to the first Atal Bihari Vajpayee National Football Competition 2024. This is Saida Rao. Here are some rules which shall be followed by everyone. Use of electronic gadgets is strictly prohibited. Time limit for final is 15 minutes per team, in which speakers shall speak according to their discretion. Time limit for the physical round is 16 minutes in total for both the teams, which is further divided into 8 minutes for each team. Time stamps will be shown in the remaining of 20 minutes, 15 minutes, 5 minutes, 2 minutes, 1 minute, and time over of every speaker, according to the time taken by the speaker. In case of any disparity, decisions of judges shall be final and binding. If the honorable bench permits, we shall begin with the final round. May it please the court, the council seeks permission to approach the dais. Much obliged. The council seeks permission to address the bench collectively as a whole. The council seeks permission to address the bench collectively as a lordship. Your lordships, in the present case of Ilonras versus Union of Pegue, the council is appearing on the behalf of the petitioner, where I, Speaker Lewis, shall be taking 30 minutes and will be dealing with the issue 1 and issue 3, and my co-counsel shall be taking 20 minutes and will be dealing with the issue 2. Now, with the permission of the bench, the council seeks permission to address the facts of the case. Your lordships, Pegue is a democratic country located in South Asia. Aryavarta is one of the northeastern states in Pegue with a vast diversity of flora and fauna. The region is also rich in ecological diversity, comprising tropical and subtropical forests, tiger reserves, biological reserves, and Ramsar and World Heritage Sites. The government introduced the fast and the safe transport
of Aravalli, which requires 9,800 acres of forest and tribal lands. The petitioner, Elon Russ, is a research scholar of PETA, conducting his research on adverse impact of infrastructure projects on tribal and tribal area. After knowing about the scheme, he voiced his concern to the joint committee, that is FASTEC and PETA. He started a protest in front of PETA and gave a speech mentioning the impact of the scheme. He also took a pledge to not let the scheme to be implemented, after which an FIR was launched against him and he was charged of section 152 of PNS. He even filed a PIL in the Honorable Supreme Court challenging the scheme launched by government and constitutionality of section 152. Now, if the Lordships are well versed with the facts, the Council seeks permission to address the issues. The Lordships kindly refer to page 16 of the memorial, where the issue 1 is stated. Issue 1. Whether the writ petition filed by Elon Russ is maintainable. The Council has tried to divide this issue onto two grounds, where the ground 1 deals with that the petitioner has an adequate locus standi in the instant case. Your Lordships, in the present case, the petitioner, Elon Russ, has filed a PIL in the Honorable Supreme Court challenging the fast and the safe transport scheme introduced by the government of Fayyoum, where he has an adequate locus standi. Locus standi refers to the right of being heard and the ability to institute a proceeding in the court of the law. Now, your Lordships, kindly refer to the flag F1 of the compendium.
Yes.
On the flag F1 of the compendium, the case of S.P. Gupta versus Union of India is mentioned. In this case, Justice Bhagwati held that where there is a legal wrong or legal injury is caused to a person or to a detriment class of person by the way of violation of their fundamental rights and constitutional rights, and such person is unable to approach to the court, then any member of the public can approach the Supreme Court under Article 32. And the Lordships, in the present case, the fundamental rights of the citizens and the tribal people are being infringed. The construction that requires 9,800 acres of forest and tribal land, which means the displacement of tribal people from that area, hence depriving them of their right to shelter. Moreover, your Lordships, the use of such huge amount of land would require deforestation at a large scale. This will cause ecological imbalance and harm to the biodiversity, which is a violation of right to environment of the individuals, citizens as well as the tribals. Tribal people are dependent on the forest produce for their day-to-day life, trade, medicine, and therefore their right to livelihood is also infringed. Moreover, your Lordships, the tribal people lack legal knowledge to seek legal redress themselves, as they belong from the underprivileged society. They don't have much knowledge regarding to the laws. And in this very present case, the petitioner Elon Russ has brought a PIL on behalf of these underprivileged sections, that is the tribal people. Furthermore, your Lordships, kindly refer to the flag F3 of the compendium, where the case of Ashok Kumar versus State of West Bengal is mentioned. Your Lordships, in this case, it was held that any member of the public or any public-spirited organization having a bona fide and sufficient public interest will have an adequate locus standi to maintain an action under Article 32 of the Constitution. Now, your Lordships, in the para 6 of the Moon proposition, it is written that Elon Russ, that is the petitioner, is a research scholar of PETA, is conducting his research on the adverse impact of infrastructural projects on tribal and tribal areas. Moreover, your Lordships, this scheme that requires the tribal land for construction. This shows that there is a nexus between the Elon Russ and the tribals who are aggrieved by this scheme. As a research scholar, Elon Russ has a professional and academic interest in the matter related to its policies. His specialized knowledge or research in this field gives him legitimate stake in the outcome of the case. Therefore, Elon Russ has a sufficient interest to maintain an action on behalf of the tribals. Moreover, your Lordships, on the flag 2 of the compendium, where the case of Vilnor Iraqi Padukappu versus Union of India is given. In this case, it was held that PIL can be maintained for violation of Article 21 or for the benefit of the poor and underprivileged who are unable to come to the court due to some disadvantages. And in the present case, Article 21 of the tribals as well as the citizens of that particular place has been infringed. The tribal people who reside on that particular place, they have the construction will require them to displace from that particular land. and hence their right to shelter, their right to livelihood would also be violated. Moreover, that deforestation at large scale will cause an ecological imbalance in the present case, and hence also violating the right to environment for citizens as well as the tribal people. And hence, in the very present case, the petitioner has approached on behalf of these tribals in the Honorable Supreme Court. Hence, it is humbly submitted before this honorable bench that in the present case, Elon Musk has an
What is stress of the 21, Article 21?
Your Lordship, right to life and personal liberty.
Yes, proceed.
Your Lordship, the second ground on which the Council has tried to establish this issue is that the scheme introduced by government lacks fairness and reasonableness. Your Lordship, the Forest Right Act 2006 mandates under Section 3 the recognition and protection of rights of forest dwelling or tribal communities. It talks about the right to hold and live in the forest land, community rights over forest resources, and customary use of forest produce. If any scheme infringes upon the land and resources of these communities, then it is said to be violative of this right, which is enshrined in Section 3 of the Forest Right Act 2006. And Your Lordship, in the present case, the scheme introduced by government requires extensive use of forest and tribal land. Tribal people are dependent on that forest produce for their day-to-day life. That is their shelter. But the implementation of this scheme would deprive them of their shelter, where they live, and also their customary rights over the forest products, overall depriving them of their right to livelihood. This is violative of their rights under Section 3 of the Forest Right Act. By disregarding the rights of tribal people and implementing this scheme, the government's action can be said as unreasonable. Moreover, Lordships, in the case of Samatha versus State of Andhra Pradesh, it was in that case it was given that in that case the importance of recognizing the tribal land rights was highlighted. Moreover, it was stated that the project must follow legal safeguards.
You are arguing on behalf of petitioner.
Immediately.
Where the respondents?
Which in the present case were followed.
It's a very lengthy your argument. Sorry.
If the Lordship doesn't have any further queries with the issue, and the Council seeks permission to address the issue.
There is some judgment of the Article 21. Quoted is here. Quoted is आपको कौन सा जजमेंट बहुत लगता है 21 को रिलीज करना है?
Meनका गांधी versus Union of India.
Latest judgment?
Latest judgment. Gaന്ധhi Gandhi for 21.
Arnav Goswami.
The Council seeks permission to address the issue 3. Issue 3. Whether Section 152 of PNS is constitutional. Your Lordship, the Council has tried to broaden the horizon of this particular issue by dividing it onto 4 grounds, where the ground 1 deals with that the Section 152 of PNS infringes fundamental rights of the citizens. Your Lordship, every citizen of a country has a right to express their grievances. These rights are specifically enshrined under Article 19, Clause 1, Subclause A, and under Article 19, Clause 1, Subclause B of the Constitution. Article 19, Clause 1, Subclause A gives the freedom of speech and expression to every citizen of the country, whereas Article 19, Clause 1, Subclause B talks about the right to assemble without arms. Now, Your Lordship, kindly refer to the flag 10 of the compendium. Is the bench with me? On the flag 10 of the compendium, the case of Mazdoor Kisan Shakti Sangathan versus Union of India is mentioned. Your Lordship, in this case, it was held that together both the rights, that is Article 19, Clause 1, Subclause A and Article 19, Clause 1, Subclause B, ensure that the people of the country has a right to assemble and protest against any of the actions or the decisions taken by the government. Moreover, Your Lordship, in the moot proposition, it is written that Elon Musk made our speech in the course of which he mentioned that how the policies of the failure government pose a significant threat to the environment, biodiversity, and livelihood of the indigenous tribe. After which, an FIR was lodged against him, and Section 152, he was charged for Section 152 of the PNS. Here, the Council's contention is that he has been curtailed by of the right of freedom of speech and expression and also the right to assemble peacefully. And both this right constitute to form the right to protest. And we watched it in the case of S.P. Gupta versus Union of India. It was held that right to protest is also a fundamental right. And Section 152 of PNS is violating this particular right of the petition. Your Lordship, Section 152 criminalizes speech and critical opinions that are essential for a democratic society, which is an unreasonable restriction on the freedom of speech and expression. And in the present case, Elon Musk was just criticizing the fast and the safe transport scheme introduced by the government, which posed harm to the biodiversity. Elon Musk with others were just exercising their constitutionally guaranteed rights.
petition जो आपने ड्राफ्ट किया है वो कहाँ है? Is it text of the judgment?
Your Lordship, in the page 16 of the memorial.
60.
That is compendium, and the
You
Lordship.
have a copy of memorial. You have extra copy of memorial.
We have submitted all the copies to the organizing committee.
Nothing there. Yes. Proceed.
Your Lordship, on the page 26 of the memorial, the issue which the council is contending, that is mentioned on the page 26 of the compendium.
This is affirmation. Judgment is there. Reading is there. Reading not is there.
Your Lordship, in the memorial, the pleading is on the page 26. This is pleading. Shall I proceed? Shall I proceed?
Which page you are referring to?
Your Lordship, page 26 of the memorial. Shall I proceed? Your Lordship, section 152 criminalizes speech and critical opinions that are essential for a democratic society, which is an unreasonable restriction on the freedom of speech. And in the present case, Elon Musk was just criticizing the fast and the safe transport scheme introduced by the government, which posed significant harm to the biodiversity, to the livelihood of the indigenous tribes who were deprived of their shelter. Moreover, to the citizens whose fundamental right to environment was also violated. Your Lordship, Elon Musk in this very present case was just exercising the constitutional guaranteed rights by protesting against the environmental impact of the government scheme. Invoking section 152 arbitrarily restricts their fundamental rights under Article 19 clause 1 subclause A and under Article 19 clause 1 subclause B of the Constitution. Furthermore, Lordships, in the case of Ramira Nadan versus Home Secretary, Union of India, it was held that the citizens have a fundamental right to assembly and protest, which cannot be taken away by any arbitrary executive or legislative action. And in the present case, Elon Musk was just criticizing the scheme that was introduced by the government. But while he was criticizing the scheme, he was being infringed of the fundamental right to protest and of the fundamental rights of Article 19 clause 1 subclause A and Article 19 clause 1 subclause B. In our present case, section 152 can be held as constitutional as it curtails these of the fundamental rights of the petitioner. The right to assembly and education are basic features of a democratic system, and government should encourage exercise of these exercises.
Okay, can we have some questions from you now? We have a question regarding your issue 1. This gentleman, Elon Musk, he filed a PIA. Right? So the basic principle of PIA is when you file a PIA, you have to establish that you do not have a vested interest. Right? So when this FIR was slapped upon Elon Musk, so there were 2 stages. Stage number 1, when a FIR is filed against you, you have a remedy to approach the High Court under Article 226 for quashing that declaration. Right? Later on, he was convicted by the Sessions Court. So then you could have challenged the validity of this section in the appeal. So how would the PIA lie in such case, especially from Elon Musk? Please tell us.
Your Lordship, in the present case, the last part of the fact sheet is also written that the PIL is filed together for challenging the scheme that is introduced by the government and
there is no barrier. Yes, sir, you are right. There is no barrier.
Indeed, Your Lordship, there is no barrier to approach.
Right.
Indeed, Your Lordship. Shall I proceed? If Your Lordship doesn't have any further questions. The second ground on which the Council has tried to put forward this issue is that the government cannot be equated with the state in such criminal questions. Your Lordship, the provisions of Section 152 of PNS should not conflate the state with the government. The state and government are here two different entities and cannot be equated. The government here does not mean legislative or executive, rather it means government in abstract. Citizens have a right to speech and expression, and criticizing government is a part of it. Now, Your Lordship, kindly refer to the case of S. Rangarajan versus Union of India, which is mentioned on the flag 14 of the compendium. Is the bench with me? Your Lordship, on the flag 14, in the case of S. Rangarajan versus Union of India, it was held that the state cannot prevent open discussion and open expression, however hateful to its policies. And in the present case, Your Lordship, the petitioner was just criticizing the scheme, that is the Fast and the Safe Transport scheme introduced by the government of the failure. Also in the moot proposition, it is mentioned that Elon in the course of his speech, mentioned that the policies of the government pose a significant threat to the biodiversity, to the indigenous tribes and the livelihood of the indigenous tribe. He was merely criticizing the scheme that was launched by the government of the failure. And this criticism of government should not be prevented. Furthermore, Your Lordship, in the case of Devi Sharan versus State of Bihar, it was held a citizen has a right to say or write whatever he likes about the government or its measures by the way of criticism or comments. Also, Your Lordship, in the case of S.D. Mohammed Khare versus Union of India, that it is mentioned on the page 13 of the compendium. Your Lordship, kindly refer to the page 13 of the compendium. Your Lordship, in this case, it was contended that the state cannot be equated with the government. Hence, a disaffection towards the government cannot be violative of Section 152 of PNS in relation to the state. The state and government here are treated as two different entities. One cannot conflate state with the government, and criticism of government policies is a part of this. Your Lordship, disaffection toward government often reflects disaffection with its policies, leaderships, or political process, while disaffection toward the state can imply a broader meaning to its connected with the nation's identity or something else. But in the present case, Elon Musk was criticizing the scheme that was introduced, and no such words were said by him to justify that he showed a disaffection towards the state. Now, if Your Lordship do not have any further queries, the Council would like to proceed with the third contention. Your Lordships, the third ground on which the Council has tried to establish this particular issue is that the Section 152 is inconsistent with the preamble of the Pale. Your Lordship, the preamble of the Constitution of Pale is of much importance to the nation. It articulates the core values and principles that guide the Constitution, including liberty. Preamble is not just an introductory statement but a crucial part of the Constitution that reflects the essence of Indian democracy and governance. Moreover, Lordships, the preamble declares Pale as a democratic government. In a democratic society, freedom of speech is of much importance. It enables citizens to make meaningful decisions about how they want society to function. It also allows individuals to have a voice in governance. Freedom of speech is seen as an essential for the discovery of truth and the full expression of individuals'